Hello and welcome to episode 64 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
I'm Joanna Baron, Executive Director of the CCF, and Christine is away today. In today's episode, I'll tell you about a newly elected municipal council that has decided it will skip the legally required oath to the king.
And we'll share a bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about the shocking position on freedom of peaceful assembly that the Trudeau government has taken in our Emergencies Act appeal. So as listeners will know, the CCF convinced the Federal Court of Canada earlier this year that Justin Trudeau's invocation of the Emergencies Act in response to the Freedom Convoy and many of the regulations made under that invocation were illegal. So to quickly recap, Justice Mosley agreed with us that the definitions of national emergency and threats to the security of Canada were not met. He also agreed that the regulations that froze bank accounts without anything even resembling a warrant violated the charter right to security against unreasonable searches. And he agreed with us that the regulations that ban traveling to certain assemblies, participating in those assemblies, funding those assemblies under threat of up to 5 years in prison violated the freedom of expression. But there was one thing that we didn't like, and we're going to talk about that today. That's that these very same regulations that violated freedom of expression, because in Justice Mosley's words, they banned a person from, quote, merely going onto Parliament Hill waving a placard, regardless of whether that person had blockaded or otherwise breached the peace, didn't violate the charter guarantee of freedom of peaceful assembly. And we ask, how can that be? So the CCF is going to ask the Federal Court of Appeal to overturn that finding, that peaceful assembly was not breached for at least some individuals, when it hears the appeal, most likely early next year. So here's the update. This week we got the government's response on the peaceful assembly question, and it was pretty stunning to all of us. We expected the government would respond and say that, even if the measures taken under the Emergencies Act limited some individuals' rights to the freedom of peaceful assembly, those limits were reasonably necessary to deal with the protests writ large and were, somehow justified under Section 1 of the Charter. We didn't expect them to argue that the Charter in Section 2C doesn't protect assemblies if they might potentially turn violent or otherwise breach the peace. And to quote them, they say, Section 2C does not protect circumstances where there is a reasonable basis to expect a non-peaceful assembly. 2C does not require the state to sit idly by until an assembly turns violent or otherwise breaches the peace. The state can intervene proactively where there is a reasonable basis to expect a non-peaceful assembly. And that's pretty astonishing, because if the Federal Court of Appeal greenlights that standard for freedom of peaceful assembly, which, by the way, has yet to be really defined, there's no test still after 40 years of the Charter, governments would have the power to ban virtually every large protest in advance, because there's always going to be some level of breach of the peace. And this would really be sending us back to the civil liberties dark ages. We really can't let them get away with this. So just to give some examples, the big one that's going to jump to everyone's mind is the anti-Israel marches and protests. And these have annoyed a lot of people. They've frankly sickened me, because you see celebration of the October 7th terror attack justified at these as some sort of justifiable resistance, which is disgusting. We're going to talk about a pretty heinous example of that later in the show. And, these protests have been mostly nonviolent, but they have led to breaches of the peace, including scuffles between pro-Palestinian folks and pro-Israeli people. But under this standard that the Trudeau government's proposing, they could criminalize these protests. They could ban them today. Whether we're talking about the, pro-Hamas protests or the pro-Israel protests, they could just make them illegal. And I know, before you say sign me up, where do I sign up? And trust me, part of me would really love to see all of these protests end. That would be really short-sighted, because if the Trudeau government could ban protests that you don't like today, a future government can ban protests that you do like, and vice versa. Under the Trudeau's proposed standard, a parental rights protest in a public park could be shut down if police have reason to believe that anti-fascists might show up and cause trouble, which would obviously give anti-fascists a strong incentive to show up and cause trouble. Police could also shut down a rally opposing, high levels of immigration, as long as it's reasonable to expect that there would be a breach of the peace, which you could readily see. They could even ban pride marches, since, Toronto Pride Parade has been blockaded by, this past summer, anti-Israel protesters, and back in 2016 by Black Lives Matter protesters, and those are obvious breaches of the peace. And, they could ban future protests against vaccine mandates or lockdowns. So anyway, the point is, if the standard they put forward, that assemblies are not protected and can be restrained in advance if somebody in the crowd might, be expected to breach the peace, we're not going to have any meaningful right to peaceful assembly at all. And, like we've argued in our factum, surely Section 2C covers a person joining a protest on Parliament Hill with a placard where she's going without any intention to blockade or otherwise breach the peace, even if someone somewhere very far away in that large crowd is doing something illegal. So, it also obviously protects a man who's marching in one of these anti-Israel protesters, even if there's a risk that some third parties are going to get into some scuffle on the side. But thankfully for those of us who are pretty fed up with the protests, I think there are a lot of things that could be done that aren't currently being done that wouldn't limit our freedom of peaceful assembly in this way. So, for example, we could enforce noise bylaws. You have a right to yell and chant and make a lot of noise, but I don't think you have a right to drive around with sound amplifiers in the back of pickup trucks, taunting all the condo dwellers like Joanna with genocidal nursery rhymes, and do it weekend after weekend. We can also enforce traffic laws. You have a right to honk your horn. You have a right to put an F Trudeau sticker on the back of your pickup truck. You don't have a right to block traffic, though, or, park illegally for weeks on end. And we could also use, and this is, I think, the most important thing probably, is use the Immigration and Refugee Protection Act to deport non-citizens who are clearly who are clearly members of terrorist groups. I think if you did that, some of these organizers of these protests would be back in their home countries and not causing all this trouble. So there's also just, forcefully pursuing criminal code charges like mischief or intimidation or rioting where riots break out. So anyway, Joanna, I know you had the same reaction to the Attorney General's factum, but is there anything else you want to say about this?
Yeah, well, so just to go back to the finding in Justice Mosley's decision that we took issue with, he essentially said if the assemblies or protests were peaceful, they wouldn't be reasonably be expected to lead to a breach of the peace. Therefore, there was no implication that cops would shut down a truly peaceful assembly, which is obviously very circular reasoning and clearly the standard of police discretion to just say, this could, because there's always the specter of something reasonably leading to a breach of the peace. And this was just way too lenient a threshold of police being able to say, as a prior restraint, we were both trying to remember what that term of law is, which is basically nothing has actually happened, but we think something might happen. As a prior restraint, this goes way too far against the right to free expression. The second thing that I wanted to say is that, it might sound attractive if we could just shut down all of the messy street activity that we've been seeing across the country and really across the world since October 7th. There's a very important rationale why we don't want to do this, because as you mentioned, most of these demonstrations, while occasionally heinous and distasteful, most of them have been peaceful. And that's just, citizens have a right to passionately express their views. And if they don't have the right to passionately and within a nonviolent manner express their views, that's when they go and just beat people up. So let's not forget that, yes, we may hate each other and we may see, people gathering outside of synagogues, yelling hateful things and celebrating massacres. But they're still not killing each other yet. And that's a good thing. And I can't remember if there was more. Oh, yeah. The last thing I wanted to just drill down on is that Yes, of course, it could be that that cops could do more things against enforcing some of the ways in which the anti-Israel protests, in particular, have gone too far. I also, by the way, think marauding through Jewish neighborhoods to just harass the residents is highly questionable content, although probably not illegal. But certainly doesn't seem directed towards any legitimate political aim. Even if we talk about ways that they could crack down on that, that is still categorically different from the law that the Attorney General of Canada is defending here in the Emergencies Act, which is basically a sweeping ex ante, prior to the fact, police permission slip to just shut down anything. I used to work as a criminal defense lawyer, and reasonable suspicion is a highly elastic standard. You know, a cop could see me walking down Bloor Street to other ship as I did this morning and say, there's something shady about this lady. I'm going to, pull her aside. They could do that under reasonable suspicion. And, I would have rights and charter claims. But the point is that it is designed to allow a high degree of exercise of police suspicion. And not just the fact that the government gave the cops this power, but gave it to them explicitly and directed them to shut down, which at the time were Freedom Convoy and Freedom Convoy supportive rallies that were happening across the country. This is just unacceptable to us. And it was just shocking, just zooming back a bit. We don't talk about politics on this podcast, but not a good look for a government that seems to be gasping for air, to be spending millions of dollars to fight these blatantly unconstitutional provisions that they took pursuant to the Emergencies Act. Like, you would think they would have a little bit of graciousness and maybe pick their battles, but Mike Fetter is their litigator that they've hired out of McCarthy's Vancouver. He's a great lawyer, and clearly taking the very aggressive route. So we'll see you in court. All right, should we take a break and then we'll come back and I will talk to you about, we'll go out to Dawson City, Yukon.
Sounds good, but I just want to mention one thing, Joanna, before the break. So we have a town hall coming up online on November 27th, where we're going to be talking all about the Emergencies Act. There's huge interest in our appeal. We might even have a date for the appeal by then. So if anybody's interested in joining that, you can go to our website, sign up for our Freedom Update newsletter, and you'll get an invitation at some point to the town hall. So let's take our break.
Okay, so now we go to Dawson City, Yukon, which, by the way, I've always wanted to go there. This is like one of the original gold rush towns, and apparently there's still like hotels and taverns that are like Wild West style. So hopefully I'll get to go there at some point, maybe to see the aurora or something. But today we are talking about a fascinating development in the local politics of Dawson City that touches on conscience rights, the relationship between Indigenous peoples and the Crown, and town councillors. So in a bold move that's raising eyebrows, all 5 newly elected town councillors in Dawson City have refused to swear an oath of allegiance upon swearing in to King Charles III. And this is typically a standard process of the swearing in procedure for elected officials, and it's mandated under the Yukon's Municipal Act. This was sparked by Councillor Darwin Lynn, who expressed hesitation at swearing the oath due to the historical relationship between the Crown and Indigenous peoples or First Nations in Canada. And then, in a show of solidarity, the other councillors, including Dawson City Mayor Stephen Johnson, decided to support and join in their colleagues' stance. So this brings up important questions about whether they have a legitimate conscience rights claim, whether the relationship between the Crown and Indigenous people makes it appropriate to take this position. And while the oath of allegiance is currently required by law, it's not explicitly part of the Canadian Constitution. The director of community affairs, named Samantha Crosby, has said basically that they are going to approach this cautiously. She said this is an unprecedented situation and that the territorial government is now exploring alternative options to ensure council members feel respected while still complying with the legislative requirements. And this could potentially lead to amendments or changes in the regulations, if not in the legislation under the Municipal Act itself. And so the councillors, however, could potentially stand to be removed from office if a solution isn't found and agreed upon within 40 days of their elections. So we'll see what happens, but this raises a lot of interesting questions. So I have a few comments. And then I was thinking about this morning, and I actually have come down on a position, which I will take a stake in this, which is that I don't believe they have a legitimate right to refuse to swear the oath, particularly as would-be municipal councillors. So maybe Josh and I will have a little bit of a debate, but here are my thoughts. So the relationship between the Crown and Indigenous peoples is, of course, complicated. Of course, the Crown, and we see evidence of this into modern day. We had the Restall decision just a couple of months ago that talked about how the Crown basically snookered out of their part of the deal, and the Supreme Court said you gotta pay up. But there's no question that the Crown has behaved in ways that, to say the very least, did not stand up to what is called in law the honor of the Crown. So I don't deny the complicated history. But the relationship between governing and governed is also complex. I think if you're stepping into a governance role in Canada, you don't get to just duck out of that history. I don't think it particularly helps to just say, I'm not going to participate in this. If you want to participate in the business of governing, we are a constitutional monarchy. We do have a particular history that is implicated with the British Crown and the Crown's representatives in Canada through the Governor General. And so I just don't think that you can reasonably just opt out of that. And this also has some interesting rhymes with a decision or an issue that came up about 10 years ago. There were a group of individuals who challenged the constitutionality of the citizenship oath. So there's a requirement under the Citizenship Act that an individual sign an oath to who was then the Queen of Canada or the Crown. And this went to the Ontario Court of Appeal, which found that it was not a violation of the expressive rights or the conscience rights of the petitioners. And their reasoning really hinged strongly on this concept that, although, of course, as she was then, Queen Elizabeth is a person, in swearing allegiance to the Queen of Canada, the would-be citizen is really swearing allegiance to a symbol that symbolizes the form of government that we enjoy in Canada. They said this fact is reinforced by the oath's reference to the Queen of Canada instead of the Queen. It is not an oath to a foreign sovereign. And in today's context, the reference in the oath to the Queen of Canada's heirs and successors, according to the Court of Appeal in a 2014 decision, is a reference to the continuity of our form of government extending into the future. And this accords with constitutional and probably the leading expert on the monarchy in Canada, Philippe Lagacé. His position was that the reference to the Queen in the citizenship oath really is a reference to the state and the source of all sovereign authority. And in that decision called McAfee, the court cites a passage from a decision called Kawaja, 2012 from the Supreme Court, where the Supreme Court held that a patently incorrect understanding of a provision cannot ground a finding of unconstitutionality. So if you're mistaken about what the requirement is that the state is putting you to, your erroneous interpretation of the requirement can't ground a finding that they're violating your rights. And at the time, Leonid Sirota, who is a law professor and a friend of mine, friend of ours, who went, wrote voluminous amounts of commentary. He was very opposed to this decision. He was very opposed to the notion that this oath could be constitutional. He made an interesting point, which is that an oath attracts different considerations, so that the comparison with Kawaja and misunderstanding was inappropriate. And he said, even assuming that this holding applies beyond context of chilling effects, it does not apply to an oath because an oath is not a provision. It's not a simple statutory command, but it is an appeal to the oath taker's conscience, and it requires the oath taker to work out the exact nature and scope of duties it imposes. So he's basically saying you're not just being asked to recite something, you're being asked to take on something like a moral obligation. And I think that's true. But I would say two things. First of all, I think that cuts both ways, right? Which, for example, if you're a Dawson City Yukon councillor and you're being asked to take an oath to the king, understanding that it's not an oath to King Charles personally, but an oath to the form of governance represented in constitutional monarchy, you can work out in your own conscience how you reconcile that with your obligations or your conscientious obligations to Indigenous peoples, to social justice, to equality, to whatever else is important to you. I don't think that there's anything inconsistent with saying that you're taking an oath and you also get to work out what that means to you. And the second point I'll say is that I think the argument for conscientious objection to oath taking was, if anything, stronger in the citizenship oath context. Although, to be clear, nobody has a hard pre-existing right to become a citizen of Canada. I personally think it's reasonable to broadly ask that somebody commit themselves to this form of democratic constitutional monarchy, but you certainly do not have a right to be a member of government in Canada, whether it's a municipal, councillor, or any other level of government. So I don't know if I've lost all of the libertarians with that position, but that's my stake in the ground. Josh, do you want to push back?
Sure, I don't mind. It's too bad Christine's not here because she is the true Republican among the three of us. But I do have some issues with the oaths, and I think that McAteer is fairly convincing, and you can, convince yourself that, okay, I'm just swearing allegiance to our system of governance, to our history, to the crown. But at the same time, when you read the oaths, it really does sound like you're, swearing allegiance to Queen Elizabeth the person, or even monarchy, and you might be a Republican, and that you might have a problem with that. So I'm a little bit on the fence and sympathetic to people that don't want to swear the oath. And I had to deal with this sort of in my own mind a couple of years ago when I articled for the Crown in Ontario. And we had to do two oaths. And one of them is pretty, it was totally fine for me. I had no issue with it at all. It's basically saying, I swear I'm going to respect the laws of Canada and Ontario. And I will not disclose or give to any person any information or document that comes within my knowledge by reason of me being a public servant. But then there were parts of the oaths that we had to swear that I was a little bit, questioned a little bit more. For example, it says, I will respect the laws of Canada, including an affirmation of the Aboriginal and treaty rights of Indigenous people in the Constitution. And of course, that's part of the Constitution, and I have no problem with that, but it's a little odd to single out, Section 35 of the Constitution, but not any other part of it. But that's fine. I didn't have an issue with it at the end of the day. And then there's the part that says, I swear I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, or the reigning sovereign for the time being, her heirs and successors, according to law, so help me God. And, I loved Queen Elizabeth. I had no problem swearing an oath to her, but some of her heirs and successors, I'm not huge fans of. So my preference for that oath would just be that it says, I swear I will be faithful and bear true allegiance to the crown, and leave it at that. But, at the end of the day, generally, I think this oath was fine, and I was willing to sign it. I'm just saying that I can see why other people would look at that and say, okay, I'm not buying this argument that Her Majesty is just the personification of the crown. And as a Republican, that really bothers me from a conscience perspective. But
a Republican who lives in a constitutional monarchy.
Right. But
to be clear, I do wish Christine was here.
I know it's a little hard to defend, but at the municipal level, do we really need an oath to the crown? Maybe not. So maybe it's okay for them to go and advocate that regulation be changed in Yukon, and maybe that the public should have that discussion. But I do think it's a rule of law issue that these councillors are going about it this way, just refusing to comply with the law rather than publicly advocating that the law be changed either before or after they're expected to swear this oath. So I do have an issue with it from that perspective. I think that's all I want to say about that. So why don't we move into our bad legal takes of the week? I guess I'll go first. So my bad legal take is related to Israel-Palestine. We had lots of options this week because that's a very controversial issue in Canada. But I'm going to focus on one that I think is the most outrageous. And first, I need to give a lot of background here because this is a fast-moving story. So last week, this flyer started circulating online. You might have seen it. It's advertising a, quote, vigil for resistance leaders to be held November 26th at Celebration Square, which is the main public square in downtown Mississauga, which is a suburb of Toronto with about 1 million people and a very large Muslim community. The flyer has a picture of Hamas leader Yahya Sinwar, who, to quote Donald Trump, died like a dog last month with a hole in his head. And this flyer had a number of, red poppies on it. And so, unsurprisingly, it triggered a lot of disgust and condemnation, which was probably part of the point. Anyway, so after this mysterious flyer began circulating, people on X started demanding that Mississauga Mayor Carolyn Parrish step in and somehow prevent this gathering. And she responded at first by saying, quote, "The city has nothing to do with this vigil. The organizers are unknown to us. They've made it look like it's a city organized event. It's not. It'll be on public property in a city public square, which is a meeting place used for hundreds of peaceful events." And oddly, she didn't even acknowledge how offensive this was or condemn it, which is what you'd expect from any normal Canadian leader to do. And anyway, someone responded to that tweet saying, "There should be rules in place to prevent the promotion of terrorism or extremist ideologies." And Parrish again weighed in, this time saying, "That would be called censorship, preferential treatment, being judgmental. The stifling of freedom of speech is something Canadians value. Yes, let's not be judgmental of people celebrating a terrorist." Anyway, that's legally correct, I suppose, but her continued refusal to, use her position of power to verbally condemn the celebration of Sinwar continued to raise eyebrows. And, one possible reason people have been talking about for her resistance is that Mississauga is home to more than 100,000 Muslims, and perhaps she thinks that if she opposes this rally, they'll punish her like Kamala Harris was punished in Michigan. But I suppose, that position it requires you to assume that most Muslim Canadians actually support Hamas, and I don't think that's actually true. In any event, people continue to call for Mississauga to ban this rally, and that led to another statement, this time on official city letterhead, which again did not condemn the gathering, but said there'll be bylaws that protect the right to peaceful protest. So story continues. On Monday, Parrish tweets out another statement, this one saying she's consulted a local network of Muslim organizations and there's no vigil planned. In other words, this is just fake. And the statement also says, quite provocatively, that Israel is committing genocide. And she, doesn't say anything to disavow this. So she's basically tweeting out that she believes Israel is committing genocide, which is deeply offensive and not true. And in yet another twist, internet sleuths have now uncovered a video of a well-known local Hamas supporter who is promoting the vigil and says it's very much true. So I guess we'll see what happens on November 26th. Anyway, that's all just background because Parrish's takes, as stupid and disturbing as they were, because she refuses to condemn this vigil, were probably legally correct in that, as we talked about earlier, you can't ex ante stop protests. You don't know what necessarily is going to happen or whether any laws are going to be broken, and people do have a right to peacefully assemble. So, police should show up and enforce the laws, but in my view, they can't do anything to stop this protest ex ante. So Lots of bad legal takes in response. I'm going to highlight one from someone named Dr. Fundji Benedict, an ex-user who is not a medical doctor, but a doctor of philosophy. Dr. Benedict writes, "Your worship, sadly, you are mistaken. I recommend you consult with the city's legal counsel immediately. The public comment you have made clearly contravenes the Criminal Code of Canada. I'm shocked that you do not understand the legal implications of what you just posted. The Canadian government has long declared Hamas to be a proscribed terrorist group. What that means is any support of said group is considered to be material support for terrorists. You're breaking the law. This is not only a breach of office and a breach of trust. This is a criminal code offense. You should know better." Now, unless you think it's illegal to allow or grant a permit to terrorists supporting people in Mississauga to venerate a prescribed terrorist, then you must immediately delete your comments and contact the relevant city commissioner and order that person to revoke the permit for this illegal demonstration. Barring that, I'm aware of thousands of Canadians who will be contacting Peel Regional Police to report you personally for providing material support to a terrorist group. As you have publicly commented that this is allowed under Canadian law, you are making it clear that you are very much aware of the nature of this demonstration. This opens you up to personal liability. You cannot claim ignorance at this point. I will tag Ontario Premier Doug Ford and Solicitor General Michael Kersner in this post. You, as the Chief Magistrate of Mississauga, are required to abide by all Canadian laws. And the post just goes on and on like that, and I won't read it all, but sorry, bad legal take. Do not take advice from doctors of philosophy, legal advice anyway, from doctors of philosophy on X. Allowing this pretty disgusting pro-terrorist rally to go ahead, assuming that it is real, is not material support for terrorism. Material support in the criminal code is things like giving money, training, or property to terrorists, and this demonstration is not likely to be illegal. The way to fight it, if you want to fight it, is show up and counter protest, and bylaw and police should go and make sure that they arrest people if any laws actually do get broken. So anyway, bad legal take, but a pretty disgusting and disturbing chapter of Canadian history, and I'm really hoping that this vigil is just fake. Joanna, what's your bad legal take?
Okay, so my bad legal take also goes, shocker, to a professor on X. My bad legal take goes to Ubaka Ogbugu, who is a professor at the University of Alberta, Faculty of Law. And he is quote tweeting Elizabeth May, who tweeted on November 8th on behalf of Canadian Greens, "I am horrified by anti-Semitic attacks on Israeli soccer fans in Amsterdam. We condemn such hate. Ironically learned of it while attending an event commemorating Kristallnacht, horror of 86 years ago. Hashtag never again." Ubaka tweets back, "Try double checking before tweeting. It might help you prevent shilling for genocide." So this is, of course, in response to the pogroms that happened late last week in Amsterdam. And from what we understand, and I have looked at kind of a bunch of news sources on this, because I know there was a bunch of muddled information, and it seems pretty clear that yes, there were a group of fans of the Israeli soccer team, Maccabi Tel Aviv, that were a group of vile hooligans that were chanting pretty gross things. But by the way, and there's, not context to say it's okay, but context I personally wasn't aware of is that European soccer teams are known to chant nasty things. For example, many fans of European soccer teams since October 7th have shown up at games chanting Hamas, Hamas, send the Jews to the gas. And also every day in probably every major city across the world at this point, there are hooligans who are chanting death to Israel, death to the Jews, go back to Poland. And would this make it appropriate to organize a hunt to beat up, throw in the water, etc., individuals who wear kufiyehs, individuals who are Muslims, individuals who appear Arabic? Of course not. No, that's not how it works. Second, I can't remember that there's ever been a concerted approach, particularly amongst academics. I also saw our friend Heidi Matthews tweeting out her indignation at the Prime Minister, Justin Trudeau, for denouncing this pogrom. I can't remember that there's ever been a concerted approach to blame the victims, and certainly the ethnic group of the victims, of a violent mob. And Elizabeth May is right to point out the parallels with Kristallnacht, which, to recall, was also provoked by a real and, in this case, a legal action. There was a 17-year-old Polish Jew who shot a German diplomat in Paris. This was as revenge for his parents' exile from Germany. And the Nazis used this as a pretext for Kristallnacht, where, of course, 1,400 synagogues were burned, 7,500 Jewish-owned businesses were vandalized, 91 Jews were killed, and then the Nazis held the Jews financially responsible for this. So luckily, what seems to happen in Amsterdam does not reach that scale. But Ubaka Ogbugu, complete lack of nuance, just flagrant victim blaming, flagrant historical tone deafness. And it is kind of funny that all of this was directed at Elizabeth May, whose own statements and certainly party have not been exactly pro-Israel. So you get our bad legal take of the week. So Josh, shall we close us out?
Yeah, that's the end of the show. So as usual, we'll ask you to rate us, review us, and subscribe if you haven't already. That includes our YouTube channel. You can support our work by following us on X, by visiting our website, theccf.ca. We're now on Instagram. And of course, sign up for that Freedom Update news for us, where you'll get weekly updates on the work we're doing. You'll get a list of legal news headlines that we're interested in and invitations to things like our Emergencies Act town hall. The CCF is a nonpartisan legal charity funded by your donations, so please click that donate button on our website if you can. Thanks for listening.